I'm Samantha Davey, and my presentation is entitled Grandparent Act or Granny Annex, Waiting for the Government. For the last 2, perhaps even 3 decades, there's been academic discussion about whether grandparents ought to have greater recognition within legal frameworks. The discussion tends to have been focused either on private law matters, such as what rights grandparents have to see their grandchildren, or on public law matters where grandparents might wish to be alternative carers for children placed in care. So in those sorts of situations, it might be that grandparents have been rejected as carers and children may be in long-term foster care or placed for adoption, and grandparents may seek to have a legal challenge in this situation. Alternatively, if grandparents are successful in being recognised as carers, this doesn't necessarily stop the challenges they may face. They may have challenges in terms of receiving financial and practical support from local authorities. So there's been various suggestions for reform. For a long time, there was a focus on the removal of the leave requirement. But more recently, I think there's been further exploration about whether there should be a presumption in favour of grandparent contact. Now, I'm not arguing that all grandparent-grandchild relationships ought to be protected, but that many of these relationships are positive and it may be in children's best interests to maintain them. So on that basis, legal reform is warranted to provide better protection to that relationship. I think too there's also a danger for unwelcome piecemeal reform by focusing purely on private law matters or public law matters or procedural issues such as the leave hurdle. So I argue that reform needs to be holistic, inclusive, and look at the bigger picture. Now, by holistic, I mean that reform should address both private law and public law matters and also hybrid cases, which may have elements of both public and private law. And that reform needs to address substantive issues as well as procedural issues which may affect grandparents. There are a number of questions which are guiding my research. Why is there a need for explicit legal frameworks to recognise and protect the grandparent-grandchild relationship? Well, currently grandparents don't have rights in English law and are not on an equal footing with parents. I'll explain some of the reasons why the grandparent-grandchild relationship is important and why it ought to be protected. What are the challenges to the effective protection of the grandparent-grandchild relationship? Well, there are several issues, especially when we look at procedural and substantive elements of the Children Act 1989. Are there specific issues we need to address when considering law reform? I will consider various issues and themes which ought to be considered, such as addressing issues in the context of both private and public law. What reforms could occur? I'll look at some of the possibilities here, focusing on what statutory reform could look like. Lastly, how can the proposed changes improve the protection of the grandparent-grandchild relationship? So why should the grandparent-grandchild relationship be protected via new legislation such as a Grandparent Act or a legislative amendment to existing legislation such as the Children Act 1989? While there have been changes in household structure and a movement away from the traditional nuclear family in society, children are living with their parents for longer, and this may include temporarily or permanently living as 3-generation households. So this means that there are children who have grown up in the same household as their grandparents and parents and have formed bonds with their grandparents as well. Greater life expectancy also means that children who may not have known their grandparents at all or during childhood only may go on to have relationships with their grandparents well into adulthood. Probably the most important one is the role of grandparents as caregivers. This can be on a temporary basis while parents are at work. So Grandparents in particular can be helpful with single parent families or while mothers are at university or work. They may also be permanent carers and act as substitutes for parents in circumstances where parents are unable to look after their children. So for some children, grandparents are not merely grandparents, but may be taking on a role as one or even both parents, therefore acting as substitute parents. Some parents can be in the background, but still play a pivotal role in sustaining the family unit, whether that's the traditional nuclear family, a single parent family, or whatever type of family that is. Grandparents do this as support providers to parents and children, or possibly one or the other. So the kind of support that they can provide can vary widely. It could be practical, such as through childcare, as I just discussed. It could be emotional, particularly for teenagers who they can act as mentors for, or even financial. So they could provide financial assistance for their children and their grandchildren. I would argue too that grandparents provide an important means of connection. I'd say that they serve as an anchor to the past in terms of children's memory and identity, and a bridge to healthy future social and emotional development. If we look at the UNCRC, especially Article 7 and 8, I'd probably put slightly more emphasis on Article 8. These articles discuss the importance of family relations and identity. Children may have strong bonds with grandparents, which are important to protect, and grandparents may directly or indirectly help to form part of children's personal identity. NGOs play an important role as well. For the last 2 decades, they've argued for greater legal recognition of grandparents and greater protection of the grandparent-grandchild relationship. Grandparents Plus, now known as Kinship, in particular, has produced several reports on this subject, which is available on the Kinship website. Although it's subtle, I would argue too that there's a slight shift in the political landscape. The government has started to acknowledge the importance of grandparents as providers of childcare. So what are the challenges faced by grandparents? There are procedural barriers before they can commence legal proceedings. There's no automatic leave to bring legal action. This was a change brought about by the Children Act 1989 to weed out vexatious claims. Some take the perspective that the barrier is so minor and that there are enough exceptions to it, which means it doesn't affect worthwhile claims. Others don't see justification for the difference in treatment, and there's an argument that there's an important symbolic distinction in the differential treatment of grandparents and parents. Limited availability of legal aid is an issue for all participants in the family justice system and affects parents too. I'd say it serves as a further burden for grandparents since they face the impediment of obtaining leave in addition to the difficulty in obtaining legal aid, and may also choose to self-represent. So this is a particular problem. I'd say this is particularly a problem in the context of public law cases. If grandparents are rejected as potential carers for children in care and seek to challenge care proceedings or an adoption, they won't be entitled to non-means tested legal aid. There's also an issue about the lack of financial and practical support for grandparent carers. There have been some improvements in the area of financial support. Grandparents are legally entitled to receive the same amount in terms of the allowance for grandchild care as foster carers, but this isn't always widely advertised, and sometimes grandparents have to fight for this. There was an important case on this issue which I refer to in my paper. They may still face difficulty in getting this financial assistance because it's not so readily available. And there may be other types of financial assistance, such as access to a hardship fund, which could be beneficial. They might lack practical support for children who have quite serious issues like emotional and behavioural problems, learning disabilities, and so on. There's also no presumption in favour of grandparent care, which means in the private law context, there's no assumption that grandparent contact is in the child's best interests. Now, as I discuss in my paper, I indicate that this isn't necessarily the best way of protecting the grandparent-grandchild relationship, but certainly this is an issue that needs to be discussed and considered further. One of the issues with reform is whether to focus on the private law regime and issues such as contact between grandchildren and grandparents, or the public law regime, which concerns issues such as grandparents as carers for children in care or as alternatives to adoption. There are also what Bainham refers to as hybrid cases. This could be, for instance, a child, so starts private law proceedings and then alleges the child is at risk of significant harm. Depending on the facts, this is a private law case which could end up with public law themes. And the reverse can happen as well. In the context of public law proceedings, it might be that a grandparent seeks a child arrangements order. So this then brings in private law. I argue that we need reform which addresses all of these aspects. So therefore, I'd say that we need to ensure any changes made, any reform should be holistic and address issues grandparents may face as carers and grandparents wishing simply to develop and maintain relationships with their grandchildren. Type of reform is another issue to consider. Should it be an Act of Parliament, an amendment to the Children Act 1989, or simply soft law guidance? This could be provided by the Department of Education or Ministry of Justice. Another bigger issue, which leads to lots of other related issues, is that most legal frameworks and many cases are decided on an unspoken preference or dominance, if you like, of the nuclear family, whether comprising of two heterosexual parents or two homosexual parents. Any measures of reform need to avoid the replication of legal frameworks based on the nuclear family. So by that, I mean two parents and however many children. And new frameworks need to avoid replicating specific problems which exist within current legislation. So the presumption in favour of parental involvement in the Children and Families Act, for example, although seen as a welcome development by many, has created its own set of problems and hasn't necessarily achieved all of its aims. I think there's also, too, a need to depart from the assumption of a binary model of childcare, specifically because it may exclude grandparents and it also may exclude other wider relationships which are still important. We're a bit behind Scotland, for instance, which has enacted new legislation, the Children Scotland Act 2020, which is based on the spirit of the UNCRC and has included reference to the need to consider the child's important relationships with other people within Section 16. I propose a dedicated Grandparent Act addressing private and public law spheres, which provides holistic reform and also serves to amend relevant sections of the Children Act 1989. I think we need to address potential barriers to accessing the court by removal of the leave requirement and improvement of access to legal aid, providing both practical and symbolic reform. The legal aid issue is, of course, a thorny one and isn't just a problem which affects grandparents. I think that there needs to be greater transparency for grandparents about when they're entitled to legal aid, and I would argue in favour of non-means tested legal aid for grandparents in care and adoption proceedings. Also, there needs to be improvement of financial and practical support for grandparents who are full-time carers. Although, as I said earlier, case law has helped to improve legal protection for grandparents, the need to provide measures of financial and practical support ought to be on statutory footing. Grandparents Plus, now known as kinship, suggest, for example, classing all children not living with parents as children in need under Section 17 of the Children Act 1989, so that such support will be provided. There ought to be changes to the legal language itself, the creation of inclusive legal language which recognises the importance of relationships other than the parent-child relationship. Inclusive legal language could be created by amendments to provisions of the Children Act 1989, specifically Section 1, Subsection 1 and Section 3. So within section 3, I would suggest that parental responsibility could be replaced with the term welfare responsibility. And in terms of section 1.1, the welfare checklist, this could be improved by adding consideration of other relationships to the welfare checklist. Now, this could take the approach of the Adoption and Children Act 2002, section 1, subsection 4F, which includes reference to relevant relationships on the welfare checklist, or the Children Scotland Act 2020, section 16, which also stresses the need to consider important relationships when making court orders in relation to children. So overall, I argue that we need inclusive, holistic and symbolic reform which makes direct reference to grandparents. We need a Grandparent Act covering a range of private law and public law issues, which could also provide for an amendment to some of the outdated and non-inclusive language and ideas in the Children Act 1989. Although the Children Act 1989 is a valuable piece of legislation and is very important, I think that it is perhaps in some respects a bit out of date now. These changes that I suggest will not only provide greater inclusivity, I think it will improve transparency of the law as well as better protection of grandparents' interests. Last but definitely not least, I think that such changes would also promote children's rights to relationships with wider birth family. This concludes my presentation. Thank you for listening.